all rise, we would have. Please be seated. We have as well.
Good afternoon, everyone. Ms. Taylor, you have the floor again for continuation of your submissions.
Thank you. Al Hassan was not the only local who cooperated with Ansar Dine. There were many, some higher, some lower. There were Arabs, Songhai and Tamashek. P643 testified that even the local authorities, the traditional and religious authorities, cooperated, collaborated even, to ensure survival. When so many people in Timbuktu collaborated, how is deterrence served by harshly punishing Al Hassan, the second Tuareg tried by this court, when Timbuktu continues to be filled with collaborators who are no different than Al Hassan? And there's nothing as concerns what Al Hassan did in 2012 that would militate against lenience. As reflected by Al Hassan's conversation with D211, when he joined Ansar Dine, they were already the most powerful group at this time. They had already taken over Timbuktu, and they had already finalized their plans concerning how Timbuktu was to be administered. This was a done deal, for Al Hassan first stepped inside the BMS. And none of the crimes for which Mr. Al Hassan was convicted occurred because of his actions. He did not initiate complaints. He did not decide the punishments. His presence and participation at floggings did not change or aggravate the way the punishments were carried out. Ansar Dine was not lacking members. If he was not present, he would have been quickly and easily replaced. The prosecution has asked you to impose a sentence of 22 years, and that is just 8 years shy of a life sentence. And we ask you, please put that number aside. It has nothing to do with Al Hassan or his actions. In fact, in the Labanga case, the prosecutor explained to the judges that for policy reasons, they will never request a sentence of less than 80% of the maximum, which is 24 years, which can then be adjusted down for mitigation. That's filing 2901, paragraph 92. Given this policy, the prosecution have a history of considerably overshooting the mark. In Labanga, they requested 30 years. He received 14. In Katanga, they requested between 22 and 25 years. He received 12. In Bemba, they said he should receive no less than 25 years. He received 18 and was then completely acquitted on appeal. The sentence range they have now requested is effectively the lowest range they have actually proposed for an ICC defendant who did not plead guilty. That means that they recognize that his culpability is less than Katanga, who received 12 years. And that is what should guide your considerations. I think your microphone's on, Madam President. I will now address the specific crimes for which the prosecution has requested the highest sentences, being torture, the war crime of passing sentences, and persecution. And turning to torture, the gravest crime was the amputation of Dede Omaiga. But Al Hassan was not convicted for the crime in the abstract sense, but for his contribution to the crime. And that is what must guide his punishment. The Chamber relied on his statement as the basis for its finding that he was involved in the arrest. And this is what his involvement looked like. On the day in question, Adam had passed by Al Hassan's house to take him to work. They passed members of the population pursuing Dede Omaiga who were accusing him of theft. To repeat, Dede Omaiga was being chased by the local population. The local population was so adamant in arresting him that even after a member of the Islamic police helped him to escape, the population tracked him down, arrested him, and handed him over. And there's no finding that Al Hassan was involved in this later arrest. Indeed, P582 gave evidence there was actually 3 arrests. In the first arrest, Dediu escaped from the Islamic police. He was then caught stealing furniture and detained at the Islamic prison. He then escaped from there with the help of a police officer. And after the second escape, he was arrested by the local population. There was thus a long, winding road from Mr. Al Hassan's participation at Dediu's first arrest to Dediu's punishment. There's no culpable finding that he wrote a police report concerning this incident. There's no finding that he had any involvement at the Islamic tribunal. He was not involved in the punishment itself and was not present. Al Hassan was shocked by the punishment. In his words, he told the prosecution he was stupefied. Before this day, the tribunal had always found ways to avoid this punishment. And afterwards, the police were more active in making sure that there were no further such punishments. So this was the first and only amputation in Timbuktu. And because of that, the details were recorded in minute detail in a way that does not always happen in the battlefield. The existence of such details, which were not known to Al Hassan, should not sway you towards a disproportionate sentence. Instead, when you assess proportionality, we ask you to do so by reference to Katanga, where the defendant was convicted for the murder of 60 civilians, of which 25 were children. There was also a significant number of women and elderly persons. And in the Katanga sentencing judgment, the chamber noted that the attackers cut up their victims limb by limb before taking their lives. And some of the survivors had to have limbs amputated to save them. Like Al Hassan, Katanga was convicted under Article 25(3)d, and like Al Hassan, Katanga was not present when the crimes occurred or in their immediate aftermath.
S'il vous plaît, Madame le juge président.
Excuse me, Your Honour, we don't have a French interpretation.
Monsieur,
Judge, thank you, sir.
I'll just check. I had mine on the original. Ça arrive maintenant?
Oui, maintenant ça arrive.
Judge, can you hear it now? Counsel? Yes, thank you, we can hear it now. But I think we missed a good 5 minutes. We didn't have interpretation for, I would say, 5 minutes.
Thank you, Mr. Sita. It appears it's the way. Merci beaucoup.
Judge Brewster, thank you very much. Is it working for you now?
Thank you very much. Sorry for the interruption, Ms. Taylor. Please proceed.
Thank you, Madam President. Like Al Hassan, Katanga was convicted under Article 25(3)d, and like Al Hassan, Katanga was not present when the crimes occurred or in their immediate aftermath. But unlike Al Hassan, Katanga was found to have been the highest ranked person in the group, and thus wielded considerable influence over the perpetrators. In contrast, Al Hassan had a lower rank than the members of the Islamic Tribunal who decided the judgment. He had a lower rank than the member of Al-Qaeda who executed it, and a lower rank than the emirs who were present on that day. Trial Chamber 2 ultimately found that a sentence of 12 years was appropriate for Katanga's contribution to 60 deaths involving mutilation and amputations. Through a winding road of liability, Al Hassan contributed to 1 amputation involving some degree of anesthesia. When considered in connection with the fact that Al Hassan exercised a lower organizational rank than Katanga, we submit that he also merits a lower sentence. Turning to the 2 young men flogged on 8th of July. And today I would like to address you on 3 aspects of this crime. First, Al Hassan can only be punished in connection with the charged allegation that each man was flogged 40 times. Second, as a result of Judge Akane's dissent, it is not feasible to impose any punishment for this crime under count 6. And third, your assessment of a proportionate sentence must take account of the ambiguous legal status of such punishments and the fact that Mr. Al Hassan executed them under orders. Turning to my first point, the counting process that the prosecutor has referred to was never conducted or discussed during trial proceedings as required by Article 74, and the Chamber cannot itself generate new evidence during deliberations. By doing so, by attempting to stitch together the chronology and sequence of flogs in these heavily modified videos, the bench would become a witness to the case, with one of those witnesses now being replaced with a judge who was not part of this deliberative process. Second, the factual finding departs from the charges, which alleged at paragraph 477 that the two individuals were flogged 40 times each. And neither the pre-trial chamber nor the trial chamber have the power to amend or aggravate a factual charge. Third, the evidence relied upon to convict Mr. Al Hassan cannot support a finding beyond reasonable doubt that there was more than 40 flogs for the purpose of sentencing. In Judge Akane's opinion, she relied on P150's evidence that the punishment was a tazir implemented directly by the police, whereas Judge Prost and Judge Mendua relied on Al Hassan's statement to conclude it was ordered by the tribunal. If we rely on Judge Akane's finding, based on P150, then we also need to take account of P150's evidence that the punishment for drinking alcohol in 2012 was 40 lashes, no more. If we use Judge Mendua and Judge Prost's account, which is based on Al Hassan's statement, then we have to consider his evidence that the flogging involved a total of 40 flogs for each person. If you use the video without either Al Hassan or P150, then you need to consider the evidence of the person who filmed the video. And his evidence was that the maximum punishment for alcohol in 2012 was 50 lashes. This leads me to my second point, which is that due to the dissents from both Judge Akane and the acquittal of Judge Mendua, there's no reliable basis to impose a conviction under Count 6 for this incident. While Judge Mendua acquitted Mr. Al Hassan, Judge Akane and Judge Prost made findings that involved different and inconsistent forms of conduct for the purposes of Count 6. These two inconsistent fact scenarios cannot both be true. There's therefore no majority finding of fact capable of sustaining a sentence. Judge Akane found that what happened on 8th of July was a tazir, that is, a punishment without a prior judgment from the tribunal. No findings were made as concerned who arrested the individuals, nor can it be assumed it was the police, given that the Hezbollah were responsible for enforcing rules concerning drinking. This means that Al Hassan's conduct arises exclusively from his participation at the flogging. Alternatively, if we look at Judge Prost's scenario, the gravamen of passing an unfair sentence relates to the lack of due process during the proceedings at the tribunal, and Al Hassan's conduct relates to his role in that process, a process which, according to Judge Akane, did not occur. The lack of cohesion concerning the factual matrix underpinning this finding operates to the detriment of Mr. Al Hassan for sentencing purposes. How is Judge Paik supposed to treat the finding? Does he adopt Judge Mendua's finding, which would equate to an acquittal? Does he adopt Judge Akane's, in which there's a complete overlap in conduct, which means no additional sentence can be imposed? Under Judge Prost, you would have to consider that Al Hassan was acting under superior orders emanating from the tribunal. So we submit that this confusion can only be addressed in a manner that respects the rights of the accused and the principle of in dubio pro rea. In case of ambiguity, the doubt favours Mr. Al Hassan, and no sentence can attach for Count 6, and no sentence can attach for any more than 40 flogs per person. And turning to my last point for this incident, Al Hassan's knowledge, Al Hassan's responsibility under counts 1 and 3 must be reduced in light of his diminished degree of knowledge concerning culpability and the restraints on his conduct caused by superior orders. Both Judge Akane and Judge Mindua found that the punishment of flogging was not in and of itself illegal under the Rome Statute. And the Chamber as a whole found that while the prohibition on alcohol was not enforced before 2012, such prohibitions were more common among Arab and Tuareg tribes, particularly in the west of Timbuktu, which is where Mr. Al Hassan is from. The Chamber further found that religious judges traditionally exercise a significant degree of influence over the population, and they also exercised a significant influence over Al Hassan. He told the prosecutor that he believed the Islamic tribunal was applying Sharia, that is, the law of God. And critically, Al Hassan admitted to the prosecutor that he was ignorant as concerns the content of Sharia. He was not in a position to know if what was decided was right or wrong, although he did believe that the punishments concerning alcohol were hudud punishments, that is, punishments mandated and required by Sharia. This is in the transcripts. Al Hassan told the prosecutor that the emir of the police chose the person required to execute the punishment, and further, that an order to execute the punishment was obligatory. Given the diminished degree of his knowledge of wrongfulness and the clear constraints as concerns his ability to depart from superior orders, we submit
A message from the interpreter. We kindly ask to speak slower.
his situation calls for a significant reduction in sentence. This is in keeping with the logic of Article 25(3)(a), which punishes perpetration, co-perpetration, indirect perpetration. And this hierarchy, as applied by the ICC, was devised by the German theorist Klaus Roxen. It was applied in practice to the situation of East German border guards, who were punished and sentenced for applying East German legal directives to shoot anyone who tried to cross the border. According to Roxen, guards acting under orders should be considered as fungibles, that is, people who are interchangeable. But true responsibility should be reserved for leaders who control these fungibles, not the perpetrator, but the perpetrator behind or in control of the perpetrator. And this analysis was most recently adopted by the Appeals Chamber in Ongwen. While German courts recognized that the orders given to border guards were manifestly unlawful, they also mitigated punishment because of the prima facie appearance of legality and the culture of obedience in the organization. The guards in question received sentences of about 1 year or 2. They also took into account the fact that the guards were praised by the regime in power for executing the orders, which is also the case for Al Hassan. The highest sentence, which was 7 years, was reserved for the leaders who devised the policy, the perpetrators behind it. This distinction between the penalty between those who execute the judgment as compared to those who devise the judgment and policy is also reflected in the World War II Ohashi case. Applying the defence of superior orders, the Australian military court acquitted 2 of the guards who participated in the execution, while sentencing the judge who ordered the execution to 2 years for their role. Mr. Al Hassan has already served more than 7 years. Without wishing to minimize the degree of suffering of victims in this case, we submit that the objective gravity is lower than murder. His sentence and conduct requires a significantly lower sentence than that which was applied to the border guards who executed the shoot-to-kill policy in East Germany and the leaders who devised it. I will now address counts 6 and 13. In her separate opinion, Judge Akani opposed a broad definition and conviction of persecution, and she joined the majority only insofar as a conviction related to other crimes for which Mr. Al Hassan was convicted. And we have set this out in our table Annex C to demonstrate the extent to which the prosecutor continues to rely on incidents for which Mr. Al Hassan was acquitted. Given this narrowing of the scope, there's a high degree of overlap between counts 6 and 13, meaning that the sentences should be similar, which the prosecutor appears to accept in their proposed sentences, even though they wildly overshot the mark. In determining an appropriate sentence for this conduct, we invite the Chamber to take account of, first, your findings that the tribunal played an important, a helpful role in filling the justice lacuna in Timbuktu. Second, your findings that Al Hassan believed he was applying Sharia in a non-discriminatory manner, and his lack of knowledge as concerns the specific procedures applied to the tribunal. Third, Al Hassan's lack of discriminatory intent before, during, and after 2012. Madam President, Your Honours, in your judgment, you found that there was a security and justice deficit in Timbuktu before the arrival of Ansar Dine. You found that after the tribunal was established, there was an increase in the volume of cases as locals came to it enthusiastically to vindicate their rights and obtain justice. You found that the tribunal was successful in promoting peaceful solutions and reconciliation among tribes. You found that the tribunal mostly followed the Malachite Madhhab school, which was also followed by the people of Timbuktu. And the Chamber relied specifically on evidence from P150 that after Al Hassan left Timbuktu, he spoke about having applied Sharia in a non-discriminatory manner. That is not a bad thing. To apply Sharia, to apply the law to everyone without discrimination, is the essence of fairness. The Chamber also took great pains to point out that Sharia was not on trial, that the application of Sharia was not in and of itself a crime. And you recognized that it would be wrong to conflate Islamic law with extremism. And we urge you to maintain this necessary distinction in your sentencing judgment. We urge you to disregard the prosecutor's attempt to conflate the notion of jihad with extremism. The word jihad means to strive. In Islam, there's a greater and lesser jihad. The greater jihad is actually the one that takes place inside, and the lesser is the one that involves interactions with others. The jihad, which is greater, involves struggling to purify one's heart, to do good, avoid evil, and make oneself a better person. In his interviews with the prosecutor, Al Hassan explained his understanding of jihad. He said that Sheikh Abdullah had described it as dawah. The word dawah literally means invitation. Dawah is an invitation to follow the path of good prescribed by God. Al Hassan told the prosecutors that he understood jihad to refer to the attention of the group to organize the administration of Timbuktu in accordance with Sharia. That is, in accordance with God's true law, which you found is not a crime. Crucially, even after being convinced of the necessity and obligation of working with Ansar Dine, after hearing Sheikh Abdullah speak about jihad, Al Hassan asked to work in the hospital. That is, He saw his own path to good as treating and caring for people's bodies, not their minds. Apart from the evidence that Al Hassan believed that the tribunal was applying Sharia, the majority, that is Judges Akani and Mandila, found that Al Hassan was not culpably aware of the specific details of the procedures or the judgments themselves. This means that both judges found that Al Hassan did not have a culpable degree of knowledge as concerns the extent to which the procedures or punishments departed from either Sharia or international law. This is now the lens through which this bench must view his responsibility for the crimes. Moreover, as cautioned by Judge Akane, this chamber cannot assume that the facts set out in the judgments were true, or that the punishments themselves were implemented in the manner recorded in the judgments. The risk of doing so is actually highlighted by case 43. This concerned 4 individuals who were caught red-handed stealing from a shop. Al Hassan told the prosecutor he was not aware of the content of the judgment or how it was handled by the tribunal. The judgment itself contains several details which were not in the police report. The judgment names the shopkeeper, it's an Arab name, and it mentions that the shopkeeper filed complaints both in relation to the theft that occurred while Ansar Dine was there and also as concerns an earlier theft. Since the tribunal knew his name, it would appear that this local Arab shopkeeper even enthusiastically came before the tribunal to follow up on his complaint. And when the police received such complaints, they were obliged to transfer them to the tribunal. The judgment states that the tribunal had to ignore the past accusations of theft because it violated the principle of legality, which is pretty fair. The tribunal also found that there was a doubt as to whether the defendants were adults, and that as such, the full penalty could not apply. The tribunal uses the word doubt. They do not say that the defendants were children or adolescents, only that there was a doubt, which allowed them to avoid imposing the full Quranic penalty. Madam President, Your Honours, your sentence can only be based on factors that have been proven beyond reasonable doubt. They cannot be predicated on a doubt. The trial chamber also received evidence that Arab shopkeepers wanted to take matters into their own hands if they caught someone stealing from shops. The application of Sharia was thus proposed as a way of calming tensions. That's D551. We therefore invite you to read between the lines, to see the different ways in which the police and the Islamic Tribunal executed their functions in a way that helped locals achieve lenience while avoiding disputes between ethnicities. It may have been rough justice, but in many ways, it was better than no justice. Viewed from this perspective, that Al Hassan was convicted for having contributed to a lack of due process in accordance with the proceedings that he genuinely believed would bring justice to Timbuktu, in accordance with God's prescriptions for achieving a path of goodness, and the Malachite school of faith followed by the local population. Viewed through this lens, the sentence requested by the prosecutor is manifestly excessive, particularly when you compare it to the sentences issued in the Hashi case. For persecution, it's necessary to take into account the absence of any finding in your judgment that Al Hassan possessed discriminatory intent. Instead, the judgment is rife with findings to the contrary. The judgment relied on evidence from both P650 and D211 that in their interactions with Al Hassan in 2012, he expressed no extremist sentiments. Their evidence is consistent with a significant body of evidence that Al Hassan was an open person. He accepted different faiths and actively facilitated the professional careers of female colleagues, a matter on which Metra Beaulieu-Lucier will expand. It is of course correct that Al Hassan was and is a Muslim. His faith was and is important to him, as is the Quranic prescription to follow a path of good. But being a believer, it cannot be equated with being a zealot or a terrorist. While the prosecutor has attempted to rely on specific video interviews to portray Al Hassan in a different light, their conclusion cannot be sustained on the basis of the evidence before you. In interviews with the prosecutor, Al Hassan told them of the context, that is, that the emirs had ordered him to participate and scripted what he was to say. The trial chamber also received evidence that many locals, including the imams, were required to read out such scripts and sermons prepared by Ansar Deen. This included sermons addressing the group's rules and the prescriptions applied by the group. I refer you to transcript 130, page 29. And when these imams and local leaders did so, they received payments from al-Mahdi for doing so. Whereas the local imams fulfilled this role every Friday, Al Hassan's speeches were negligible in number and effect. And while the trial chamber found that these videos reflected Al Hassan's enthusiastic participation in Ansar Deen activities, the chamber made no finding as concerns what his enthusiasm related to. This bench cannot now plug that gap by making a more specific and prejudicial finding on this point. There's also nothing wrong about being enthusiastic about a reduction in crime, an uptick in security. Al Hassan's sentiments echoed that of many locals, including notables like P654, P4, D553. Al Hassan's actions also speak louder than words. Critically, after the amputation of Dedi Rumayga, there were no amputations in Timbuktu. And this was not purely by chance, as Al Hassan, along with other locals, used their position to save people. And I refer you to the examples in our sentencing brief. On this basis, it is our submission that Al Hassan's circumstances are no more culpable than that of Vlatko Preskic. He was a police operations officer convicted for accessory liability in connection with persecution. And while acquitted on appeal for evidentiary reasons, the quantum of sentence is relevant to this case. Like Al Hassan, Vlatko Preskic displayed no persecutory intent before the attack in question. Like Al Hassan, Vlatko Preskic was found to have assisted in logistical preparations and to have assisted by being present on the day of the attack. This was found to warrant a sentence of 6 years in connection with a persecutory attack in which 116 Muslim civilians, including women and children, were killed. A further relevant yardstick can be found in the case of Milan Kvero, the Assistant Commander for Moral, Religious and Legal Affairs, who received a 5-year sentence in connection with convictions for persecution and inhumane treatment related to a joint criminal enterprise to forcibly remove thousands of Muslim men in Srebrenica. And of relevance, while Guevara played an important and senior role in operations, he played no role in the decision-making processes that led to the crimes, and his contributions were not decisive. Madam President, Your Honours, that conclusion applies equally to Al Hassan. The Chamber found Al Hassan's contributions to be of a residual nature. The word residual refers to what remains after the greater part is gone. We ask you to follow the same logic in imposing a residual, that is, a lesser sentence for his contributions. Now, just turning to the point of sentencing credit, today the prosecutor has turned and relied upon the transfer of Mr. Al Hassan between the French and the Malian authorities and claimed that this proves that he was detained in Bamako for other conduct. In fact, it proves the opposite. At page 9941, it says, reasons for the retention. And those reasons, in black and white, are that Al Hassan connaît Iyad Ghali depuis 2012 et reconnaît travailler à son profit. He was detained for knowing Iyad Ghali and having worked with him since 2012. You've seen the arrest warrant against Iyad Ghali. You've seen the overlap in conduct. The fact that the conduct domestically was greater does not mean that it did not encompass the same conduct as the ICC. And whereas there is a domestic dossier against Mr. Al Hassan for 2012 events, there is no other domestic dossier. Now, the prosecutor has told you not to speculate. We invite you to do the same. What is in black and white here, what is in the letter of the French Ministry of Interior, is clear and abundantly supports the threshold of balance of probabilities. He was detained for his role in working with Iyad Ghali, with working with Ansar Dine since 2012, and that is enough. Turning to my conclusion, Madam President, Your Honours, Al Hassan seeks the pardon of the people of Timbuktu and all those he harmed. This wish was expressed in his written statement and is conveyed today publicly on his behalf. These sentiments fall squarely within the parameters of remorse defined by the ICTY Appeals Chamber in Struga, the Appeals Judgment, Para 365. Al Hassan has no wish to cause harm. He loves Timbuktu. He would love and be willing to return to promote reconciliation and peace among communities. But he will also respect the wishes of the people of Timbuktu and the victims in this case. As Maître Beaulieu-Lucier will elaborate, the most important thing for him is his family. And he's asking you for the chance to take care of them, to be there for them, and to use the time he has left to help guide them on a path of peace and reconciliation. Thank you. I will now turn the floor over to her.
Thank you, Ms. Taylor. Ms. Lucienne Beaulieu.
Madame la Présidente,
Madam President, honourable judges, Your Honours, it's an honour to address you today. I will speak about Mr. Al Hassan's personal circumstances before and after 2012, why these circumstances differentiate Mr. Al Hassan from other detainees, and why these circumstances should be taken into account and mitigate the appropriate sentence for this individual. I would also like to explain to you the reasons for taking into account the impact of the exceptionally severe restrictions during the pandemic and the experience of Mr. Al Hassan's detention in Bamako under the State Security Services for the acts of 2012 and its impact on detention here in The Hague. Mr. Al Hassan is a man who has already suffered enormously from the severe consequences of the crimes for which he was found guilty. Not only has been deprived of his liberty for over 7 years, he's been deprived of his family, his community, since he was arrested by Boakan in April 2017. He has missed the birth of 2 of his children, and he has had to mourn the death of his daughter in prison, thousands of kilometers from his family. This simple fact has a particularly deterrent effect on Mr. Al Hassan, and it already achieves this particular objective of deterrence. The objective of punishment has already also been achieved. In fact, the sentence is already served in Bamako and The Hague, is already sending out a strong signal which makes it possible to express the international community's indignation at the commission of the crimes for which Mr. Al Hassan has been convicted. The words of your judgment are already a punishment, a sentence, and it is a signal to the local and international community. More time in prison will not send a stronger message. Detention takes place in private, far from sight. What sends a strong message are the words, the label that is put on Mr. Al Hassan last June. The objectives of a prison sentence, and here I put it to you respectfully, have already been achieved. All of the personal circumstances of Mr. Al Hassan point in the direction of positive rehabilitation and peaceful reintegration into his community. On the basis of your conclusions contained in the judgment, the prosecutor considers that Mr. Al Hassan deserves a sentence of 22 years imprisonment. I put it to you respectfully and without diminishing the seriousness of your conclusions, that the prosecutor's suggestion does not hold water. It is a sentence which is completely disproportionate to the personal situation of Mr. Al Hassan, even weighing the gravity of the crimes against his contribution. If we consider already last year in Bamako, the 6 years spent in detention in The Hague, nevertheless, Mr. Al Hassan will have to serve a further 15 years in prison. Mr. Al Hassan would be released in 2039. He would be 62 years old, considering that he was arrested when he was 40. We need to bear in mind that the World Bank in 2022 established that the average life expectancy in Mali will be 58 years, and his eldest child will be approximately 29 years old. He will barely have seen his last son, who he had not met, and who will be 16 years old. Madam President, Your Honours, Mr. Al Hassan has been sentenced, but he remains a human being. Mitigating factors mitigate the sentence, but not the crime. Mitigating factors enable the court to impose an individualized and proportionate sentence. I now turn to these mitigating factors in further detail. Where it concerns Mr. Al Hassan's character, the defense presented evidence painting a picture of Mr. Al Hassan before and after the events. Mr. Al Hassan was presented as a man dedicated to his community, prepared to work for free, to ensure access to healthcare in his locality, and this before and after 2012. He was described as a man who helps people in need, regardless of their ethnicity, their gender, or their financial means. He has also been described as an open-minded person who respects religious practices different from his own. In the Popovich case, the trial chamber emphasized that an appropriate sentence must reflect the character of the convicted person, the good character of an individual before the events, and the absence of a previous conviction are mitigating factors. You have read Mr. Al Hassan's words. He evokes no desire for revenge, quite the contrary. His faith enables him to get through life's merciless ordeals without holding any grudge against anyone else. He forgives the people who tortured him. The truth is that Mr. Al Hassan is not an extremist, and he's already shown his potential for rehabilitation and his capacity to reintegrate into his community. The family circumstances also militate in favor of mitigating his sentences. Most detainees have families. They have wives, they have children. But Mr. Al Hassan's situation is a little more distinct, it's more different. He is responsible for his family, his 7 minor children. His family currently lives in a situation which is extremely precarious. It has to move constantly because of the growing insecurity in Mali. And all this without the protection of the family's head, Mr. Al Hassan. He's not there to look after his family. He cannot ensure their safety. Since the beginning of his detention, it has been his parents who look after his children, and in particular his father, who's 81 years old and is practically deaf and blind, whereas it is he who should be taken care of. The pressure that Mr. Al Hassan's detention has on his family is immeasurable. Mr. Al Hassan said in his statement, and I paraphrase, "Visits from my family to The Hague have brought me great joy, but also great sorrow when I see them leave. I would really like to be able to see them now, but I'm too worried to ask them to travel. I'm not there to protect them, and I can't put that responsibility on my parents' shoulders. I cannot favour my own happiness at the detriment of my family." His parents will soon no longer be able to look after his entire family because of their age, and the security situation in Mali is not improving. On top of this, Mr. Al Hassan's family is also in a particularly unique situation of additional insecurity for which Mr. Al Hassan is not responsible, and I refer the Chamber to paragraph 31 of our Rule 68 application for the admission of Mr. Al Hassan's statement. The extreme situation in which his family finds himself while Mr. Al Hassan is in detention has a particularly deterrent effect on him and weighs heavily on him and his family. Courts have taken into account the personal circumstances to reduce sentences in the Orich case at the ICTY and Katanga case in this court. This should also be the case here. Furthermore, the impact of the ill treatment suffered in detention in Bamako on his detention here in The Hague, combined with the difficult circumstances during the pandemic, are factors that should be taken into account in the sentence of Mr. Al Hassan. He is not a detainee like the others. His particularly traumatic experience of detention prior to his arrival in The Hague has left its mark and has aggravated his punishment in The Hague, in detention, from the outset. And it's been all the more aggravated during COVID. Nor is it a question of establishing a diagnosis, nor is it about determining who is responsible. What we are asking this honourable court to do is to assess and grant a remedy for the impact of the acts suffered at the hands of the security services in Bamako on Mr. Al Hassan's detention here. This honourable chamber has never denied that Mr. Al Hassan was tortured in Bamako. Madam President, Your Honours, you have read in detail what Mr. Al Hassan experienced in Bamako. You have seen it. You have seen what was going on in his head. He can never change what happened to him. He accepts it, but it is forever engraved in his DNA. He lives it night and day. He lives in his head, like in a prison, inside a prison. Every day, he constantly experiences a double punishment. This element forms an integral part of Mr. Al Hassan's personal circumstances, of the man who stands before you, and for whom you have the onerous task of establishing an appropriate and individualized sentence. When he arrived in The Hague in 2018, Mr. Al Hassan was already in a distress that is unique to detainees who've survived torture. He himself testified that all night, when he heard somebody approach, he thought they were going to kill him, and he relived the same nightmares as when he was detained by the security services. During his detention in Bamako, he spent 4 months handcuffed, without a break, every day. And when he arrived in The Hague, he continued to sleep for 1 year in a fetal position, as if he was still handcuffed by way of habit. A number of national courts have taken the difficult conditions of detention into account in order to reduce the prison sentence to be served. For example, in France, in the case of Saïssa and Ben Chali. According to the case summary, the applicants accused of terrorism-related crimes were given a reduced sentence in France because of the difficult conditions of their detention at the Guantanamo base. In this case, a doctor filed a report alleging that the ill treatment and the particularly precarious living conditions, the forced isolation, the uncertainty of tomorrow, maintained day after day, the danger of potential reactivity by the extensive interrogations will leave traumatic traces on the person concerned. Your Honour, Your Honours, this is the same fate that befell Mr. Al Hassan at the hands of the security services, and which enabled these individuals to receive a reduced sentence. No matter what diagnosis or label is applied to Mr. Al Hassan, just like Mr. Sassi and Ben Chali, Mr. Al Hassan will bear the marks, the scars of his detention in Bamako for the rest of his life. These are the marks that must be taken into account in the determination of the appropriate sentence for him. All detainees experience different things in prison, but not all detainees have been tortured in detention. This is an additional layer of suffering, which makes his experience of detention more difficult and makes his punishment that he undergoes every day more intense. Now, just as his condition was beginning to improve, the pandemic arrived, and at the same time, the opening of his trial. The whole world was disoriented. Imagine what it could do to a torture survivor, an individual who needs stability, certitude, when all of a sudden his conditions of detention are changed, solitary confinement is increased, face-to-face contact is cut, and visits with his family and lawyers are reduced. The trial began in July 2020 at the very beginning of COVID, during the worst months of the pandemic, while the measures were renewed every month, leaving no predictability. Mr. Al Hassan was also the only one to be standing trial at the time. Now that we have left these dark days behind us of the pandemic, it's hard for us to remember what our lives were like. But I would ask you to remember that period and remember the first months and the extreme fear that we felt. Here in the court, you will remember what it was to go to the courtroom and the fact that Mr. Al Hassan had to follow his trial from the detention centre without direct contact with his lawyers. Mr. Al Hassan went through this period like everyone else, but the impact on him is not the same. What sets Mr. Al Hassan apart is a particularly traumatic experience of detention prior to his arrival in The Hague, which aggravated his detention in The Hague. Mr. Al Hassan, in his statement, testified that, without contact with people, I had a feeling of moral isolation. I had somehow found new bearings here after being uprooted from my country, my culture, my family and my friends. But with COVID, I felt that I had lost my bearings once again. I was disconnected and lost, or disoriented and lost. From his arrest in 2017 to his transfer to The Hague, he was held incommunicado. He had no contact with his family. It was only after 1 year in The Hague that he was finally able to receive a first visit from his family in The Hague. And while a second visit was meant to be planned, the pandemic arrived and the family visits were suspended. Mr. Al Hassan did not see his family again for 2.5 years. 2.5 years in a situation of great stress is an eternity for anyone, but even more so for someone who has lived through for what Mr. Al Hassan experienced in detention in Bamako. He didn't know if he was going to see his family again. Once again, each change was experienced as a re-traumatizing event. Each change plunged him back into the nightmare of the DGCE, the uncertainty of it all. During this period, Mr. Al Hassan lost a child taken by malaria. And the reason for because of the COVID measures, Mr. Al Hassan was unable to see his wife, the mother of his daughter, and grieve with her for 10 months. Imagine not being able to hold your wife, the mother of your child, in your arms in this situation for 10 months, not being able to comfort her, not being able to console the brothers and sisters who've lost a sister for 10 months. When this second visit took place, Mr. Al Hassan finally met his son, who he still hadn't met, and who at the time was 4 years old. Since his arrest in 2017, he has seen his family a total of 4 times, each time lasting 10 days. He has spent approximately 40 days with his family since April 2017. The case law of this court is clear that family visits are imperative to ensure the well-being of detainees. In a decision of the United States Court of Appeals of the District of Columbia, the court concluded, I quote in English,
A prisoner is entitled to a remedy when, though lawfully in custody, he is deprived of some right to which he is lawfully entitled, even in his confinement. The deprivation of which serves to make his imprisonment more burdensome than the law allows, or curtails his liberty to a greater extent than the law permits.
So the COVID measures deprived Mr. Al Hassan of his rights to family visits for several months, despite the fact that it was nobody's fault. National courts have also taken into consideration the impact that COVID could have on individuals who already have a pre-existing vulnerability without necessarily having to establish a specific diagnosis. For example, in Canada, New Zealand, and Australia, several courts have considered that the conditions under which the accused were detained during this period were much more restrictive than normal. And we currently have a vision of the pandemic which is different to that in 2021. Mr. Al Hassan should be able to benefit from the mitigation of his sentence because of COVID, like all detained persons in the rest of the world. Mr. Al Hassan has expressed his wish to find a job on leaving prison that would enable him, quite simply, to take care of his family. He wants nothing more than to be able to be with them, ensure their safety, provide them with a roof over their heads, and live a quiet life in peace with them. Every part of this case is tragic, including what happened to Mr. Al Hassan. Acknowledging this in no way diminishes the suffering of the victims in this case. I would like to thank you, Madam President, Your Honours, and I will now give the floor to my colleague, Ms. City.
Madame.
Thank you.
Please proceed.
Good afternoon, Madam President. Good afternoon, Your Honors. My name is Havneet Sethi, and I stand here on behalf of Mr. Al Hassan. Today, I am addressing 2 issues. The first, the absence of aggravating factors in this case, and the fact that those forwarded by the prosecution have either not been proven beyond a reasonable doubt or were not objectively foreseeable to Mr. Al Hassan. The second, that the prosecution's arguments on gravity and aggravating circumstances are based on material findings already incorporated into the trial judgment and therefore constitute an impermissible use of double counting. Turning to the first issue, the lack of aggravating factors. The prosecution has failed to demonstrate, to the requisite standard, the existence of aggravating factors in respect of Mr. Al Hassan. The burden rests with the prosecution to prove these aggravating factors beyond a reasonable doubt. There must be a sufficiently proximate link between the factor and the crime or crimes in question. Any inference drawn must be the only reasonable inference from the available evidence. The defense cannot be expected to disprove a negative. Contrary to the prosecution's submissions of this morning, Mr. Al Hassan is not a zealot. The prosecution has failed to demonstrate, much less prove beyond a reasonable doubt, any evidence of repugnant, sadistic, or depraved behavior, nor has it established any evidence of robust participation and dedication to criminal activity, much less an engagement with behavior of brutality. For that is the standard, Your Honors. The law is clear. Zeal requires a very high threshold. Carrying out one's tasks with dedication does not equate to eagerness to carry out the crimes, and doing your job does not necessarily make you a zealot. Your Honors, propaganda is not zeal. This chamber has found that one of Mr. Al Hassan's jobs was to speak in support of the group's activities, of its missions and objectives. It also found that he demonstrated enthusiastic participation in certain video communications in respect of their activities. It also found that these types of communications were part of the group's propaganda activities. And perhaps most importantly, that these types of propaganda activities were supervised by a media office that routinely engaged in censorship. The prosecution has failed to show that the only reasonable inference from Mr. Al Hassan's appearances in these videos is zeal. It has failed to demonstrate volition, to say nothing of eagerness or robust participation. Indeed, this chamber has, through its own findings, provided us with an alternative reference, reasonable reference. Alternative reasonable inference. In footnote 3736 of the trial judgment, the chamber found in one of these video appearances that Mr. Al Hassan may indeed have been reading from a script. It took note of his statement that the media office had written out and provided him with what to say. This means, Your Honors, that there's another, equally plausible, equally reasonable inference in respect of his appearance in these videos. One that does not assume he's a zealot. Rather, there's a very real possibility, recognized by this chamber, that his message may have been a scripted one. And reading a script is not zeal. In any event, Mr. Al Hassan's participation in propaganda activities is not unlawful. The Popovich chamber makes clear that propaganda does not equate to zeal. Milan Guerrero, one of the defendants in that case, was entrusted with key functions in relation to external propaganda. Despite full and actual knowledge of the military's intention at Srebrenica, he deliberately spread misinformation intended to mislead and curtail the international community's ability to act. And yet, despite these purposeful efforts to mislead the international community, the trial chamber found that there was absolutely insufficient evidence of zeal or enthusiasm. Finally, it must be noted that aggravating factors cannot be established in relation to uncharged offenses and allegations. Accordingly, even if the trial chamber's factual findings suggest that certain offenses may have occurred, but no conviction was entered on the basis of those facts, no aggravating circumstances may be inferred from those findings. The prosecution's reference to P0641's hearsay evidence concerning threats to a third individual cannot be considered. First, this was an uncharged incident, never fully tested in court, and which did not form part of Mr. Al Hassan's conviction. Second, it was premised on hearsay. P0641 was not present when the incident occurred and learned of the story from the man who claimed to be the victim. In light of its diminished probative value, reliance on hearsay evidence to reach the requisite standard is inappropriate. Furthermore, P0641 placed two different inflections on the hearsay account. In the absence of an ability to confront the source with a view to establishing the truth of the event, this chamber cannot safely choose between these two versions to make the aggravation assessments to the standard required. His account of the incident fails the standard and accordingly must be dismissed. Your Honors, before we turn to the issue of foreseeability, the defense takes this opportunity to respond to the submissions of the prosecution and the legal representatives of victims this morning that Ansar Dine targeted the whole city of Timbuktu, an entire population. This is simply untrue. This use of rhetoric is unhelpful, and the case law is clear. An offender can only be sentenced for those crimes for which he was actually convicted. And, as noted by Ms. Taylor during her submission, Mr. Al Hassan was acquitted of half of the charges. The prosecution's position is specious, and this argument should be dismissed, and we trust that this chamber will craft a sentence that is faithful to the verdicts. Moving now to the lack of objective foreseeability. Your Honors, Mr. Al Hassan cannot be held responsible for those actions or consequences not objectively foreseeable to him at the time of the events. The prosecution's position that Mr. Al Hassan must be held responsible and his sentence aggravated for circumstances of Dedu Maiga's amputation, for example, or the fact that P554 was briefly exposed. This is untenable and must be rejected. The prosecution, the spectrum of culpability ranges from objective foreseeability to awareness to intent. An aggravating factor must, at the very least, have been objectively foreseeable to the defendant at the time of the crime. And the prosecution must prove this beyond a reasonable doubt. Your Honors have already heard from Ms. Taylor the circumstances leading to and of Mr. Maiga's arrest and sentence. You will remember that Mr. Al Hassan was not present at the administration of that sentence. This chamber also found that Mr. Maiga suffered social rejection after his punishment. What it did not find was that Mr. Al Hassan was responsible for that punishment. For that rejection, and that he contributed to it, or that it was even objectively foreseeable. In the absence of such a finding, the prosecution is precluded from now making or relying on such an argument. Nor did this chamber find that Mr. Al Hassan played any role in the broadcast or advanced publication of sentencing information. In the absence of a finding by this chamber that Mr. Al Hassan was culpable of such actions, he cannot be held responsible. The public attended the sentences of their own volition. It is unjust to suggest that Mr. Al Hassan must now pay the price. Turning to another incident, the aggravating factor of publicity does not apply in the incident in respect of P554. The prosecution has failed to prove beyond a reasonable doubt that it was objectively foreseeable to Mr. Al Hassan that P554 would be briefly exposed during his sentence. The trial chamber has found that P554 was arrested and detained by Hezbollah under the command of Mohammed Musa, against whom many Ansar Deen members had filed complaints and tried to distance themselves. The trial chamber did not find that Mr. Al Hassan had any involvement with P554's arrest, detention, sentence, or exposure. Indeed, in paragraphs 842 to 844 of the judgment, Mr. Al Hassan is conspicuous only by his absence. His culpability in respect of this victim was through the operation of Article 25(3)(d). Your Honors, keeping in mind that Mr. Al Hassan had no knowledge of her arrest, her detention, or her sentence, would it be appropriate or just to say that it was objectively foreseeable to Mr. Al Hassan what would happen? Has the prosecution proven beyond a reasonable doubt that it was objectively foreseeable to Mr. Al Hassan, despite other women having undergone similar sentences, that this would happen to P554? We would submit, Your Honors, that the answer is no. Nor did Mr. Al Hassan have knowledge of P565's arrest, age, or eventual sentence. In fact, the chamber found that the police arrested P565 because she identified the location of her detention as the BMS, which was at that time the headquarters of the Islamic police. It did not find that Mr. Al Hassan arrested her. The chamber also did not find that he subsequently learned of her arrest or her sentence. The prosecution has not demonstrated that Mr. Al Hassan knew of her age or that it was objectively foreseeable to him that she was 14 and would be sentenced as she was. It should also be noted, in this respect, that P565's sentence was the first of its kind since Ansar Deen began operating in that region. No such punishment had ever been carried out. We ask you, Your Honors, if it is truly objectively foreseeable that in June 2012, in a context where no such sentence had been issued or carried out, and where Mr. Al Hassan was not aware of a person's arrest, detention, or sentence, or even her name and age, that he could have known she was vulnerable. Again, Your Honors, we submit the answer is no. Turning to the second issue, Your Honors, that the prosecution relied on material findings already incorporated into the trial judgment to argue gravity and aggravating factors. Your Honors, this morning, the defense provided to you a visual aid. We now draw your attention to the entries in blue and pink of Annex B, which is being displayed in front of you. Go down. Taken together, these entries are taken directly from the prosecution's sentencing submissions and the judgment itself. Your Honor, do you have it in front of you? Would we... Pardon me, what's he saying? It is. Nothing. No, it's good. Pardon me. I can't see it. Yeah? Okay. We simply would like to draw your attention to the entries in blue and pink. These are taken from the prosecution's sentencing submissions and the judgment itself. And taken together, they detail the impermissible use of double counting by the prosecution. As Your Honors can see, there are many. Indeed, it is well established that any factors assessed in relation to the gravity of the crime cannot later be considered as an aggravating factor, or vice versa. Your Honors, I spoke earlier about P554's brief exposure during the administration of her sentence. This incident has already been incorporated into the Chamber's findings on torture. So too has the Chamber's material findings on the physical element of the crime. The prosecution's attempt to double count these findings to now argue both gravity and aggravation is impermissible and should be disregarded. The Chamber found that children were present during the sentences of most of the flogging victims. It also found, however, that the public nature of the punishment and the presence of children intensified the victim's suffering. These factors, taken together, satisfied the first element of the crime of torture in respect of these victims. This has already been considered by the Chamber. Similarly, the Chamber also relied, in paragraph 1311 of the judgment, on P565 and P557's detention conditions, to find that the first element of torture had been met. Specifically, the Chamber found that the detention conditions formed part of a series of acts perpetrated against these two victims, which, taken together, satisfied the element of pain and suffering. This means, of course, that these conditions cannot now be relied upon by the prosecution to argue aggravation in relation to counts 1 and 3. Now, regarding the prosecution's use of discriminatory intent, Your Honors, this isn't just a case of double counting. It is triple counting. The Chamber relied upon discrimination to find the existence of an attack pursuant to an organizational policy, a requisite element of Article 7's chapeau. The Nitaganda Chamber has found that where the organizational policy of a non-persecution crime contained a discriminatory element, that any factors taken into account in the gravity or aggravation assessment of the non-persecution crime cannot then be taken into account again when assessing the gravity or aggravation of persecution. This Chamber has found that Ansar Deen's common purpose entailed a discriminatory element. It also found that Mr. Al Hassan was responsible under Article 25(3)(d) for contributing to the enforcement of these discriminatory rules through his role as a police officer. Given that these factors have already been relied upon in material findings by this court on the modes of liability, they cannot now also be relied upon in aggravation assessments. These arguments must be dismissed, Your Honors. In determining an appropriate sentence, a distinction must be made between individuals who have allowed themselves to be drawn in and those who have initiated or aggravated the situation. We ask you to take that into consideration today, Your Honors, as you consider the specific degree of Mr. Al Hassan's involvement. You have found that he contributed. The question now is, how much did he contribute, and how much more do we want to punish him over and above what he has already lost? Your Honors, we've spoken to you today, my colleagues and I, about the man that Mr. Al Hassan was in 2012, who he was before and after the events at issue, and the man he now wants to be. And we ask you, on the basis of what you've seen and what you've heard, to let him be the son, the husband, and the father that he would like to be. Thank you.
Thank you very much. Ms. Taylor, does that conclude the submissions of the defense?
Thank you, Madam President. Yes, it does.
Thank you very much. Thank the defense for their submissions. At this juncture, I'm going to turn to my colleagues to see if they have any questions. Judge Academy, no. Judge Pack, no. I have one question for the prosecution. Mr. Duterte, it relates to the issue of cooperation as a factor, potentially mitigating factor. As I understood your submission, you acknowledged that Mr. Al Hassan was cooperative in providing a statement, lengthy statement, which has been admitted before the Chamber, but you took the position that that was not of relevance for the Chamber in considering cooperation as a mitigating factor because it was prior to the issuance of the arrest warrant, and you focused then your analysis on cooperation on those subsequent, his subsequent acts in terms of cooperation. Is that your position, that cooperation in an investigation prior to the arrest warrant issuing cannot be taken into account as a mitigating circumstance, or is it more nuanced than that? I'd appreciate a further explanation on how you consider cooperation to be evaluated.
Madame la Présidente, je vous remercie de
Mr. Duterte,
l'opportunité
thank
de
you, Your
clarifier
Honour,
cela.
and thank you for the opportunity to
C'est en réalité
clarify
les
this.
circonstances qui suivent
It would have been the circumstances that
cette
followed
interview
that
qui
interview
conduisent à accorder
that
extrêmement peu de poids
lead ones to attribute little weight
interview qu'il a donné
to
volontairement.
that interview, which he did
Dès
give
que le
voluntarily.
mandat d'arrêt a été
Once the
émis,
arrest warrant had been
il n'y a eu
issued,
absolument aucune coopération pour la
there
raison
was
que j'expliquais,
no further
malgré
cooperation
ça,
at all for the reasons that I
des
described.
contestations de tous les éléments du dossier. Et c'est son droit,
All
je le
aspects
conteste
of
pas.
the case were disputed by him, and that's
et
right, I
naturellement,
don't contest that.
Le fait qu'il a fermement opposé
And of course,
l'admission de cette interview.
naturally, the fact that he
au dossier
firmly
Donc, dans le cadre de l'enquête, il est difficile de prendre en compte
stood
la
against
coopération, un
the
interview qu'il a donné,
admission
alors que
of
lui-même
that
s'opposant
interview
suite à ce qu'on l'utilise.
into the file. So he
Et si tant est qu'on
steadfastly
puisse
stood
y donner
against
un peu
the
de poids,
use
et je ne
of
veux
that
pas
interview,
préjuger de la décision de la
and
Chambre
that's
à cet
why
égard,
I believe that the
compte tenu
chamber
de
should
cette
give little weight
opposition,
to it without
c'est son droit de s'opposer à l'admission
prejudging
de cette interview.
or anticipating what the
Très peu de
chamber
poids
might
obtenu
find.
en termes de coopération.
I would suggest
quand on
that it
compare
should be accorded
avec
very
d'autres,
little
comme
weight
Monsieur Almadi,
under the rubric
effectivement,
of
le jour et la nuit.
cooperation. And if we compare this to Mr. Mahadi's conduct, it's day and night.
Thank you very much. That clarifies the point for me. I have no further questions. Any questions arising, comments arising out of that?
Madam President, may I be permitted to briefly address the response of the prosecution to have the last word?
Certainly, you can comment. It arises out of the question from the chamber.
Thank you very much, Madam President. I just have 3 brief points to make in response to that.
I'm sorry, Ms. Tell, is this in response generally to the prosecution's submissions or just to this point?
Just to this point.
That's fine. Thank you, Ms. Taylor.
Thank you very much. The first point is this issue of volition. The prosecutor has argued that Mr. Al Hassan opposed the admission of his statement. That opposition arose from the question as to whether the statement was voluntary or involuntary. The trial chamber found it was voluntary. It therefore in and of itself constitutes voluntary cooperation. My second point is it's our submission that pre-arrest cooperation should be given more weight. Because there was no arrest warrant against him, there was no quid pro quo. This was a lengthy example of full and extensive cooperation where he was given nothing in return. He asked for nothing in return. And because there was no arrest warrant against him, he was not minimizing his role or trying to obtain something. My third point is that we need to separate 2 distinct things. The first is his statement and the extent to which that constitutes cooperation. And the second is the issue as to whether we agree to any facts in the case. And the jurisprudence is clear that you cannot say that a failure to agree to admit to agreed facts can be used against the defendant. He cannot be penalized for exercising his statutory rights. So what you have before you is an example of clear and pure cooperation. Anything else cannot be taken into account to mitigate that or to lessen its weight. Thank you.
Thank you very much, Ms. Taylor, for those comments. Unless there is anything further from any of the parties, and I'm not seeing any indication of the participants to that effect, that brings us to the conclusion of this hearing. The chamber will retire to deliberate and will notify in due course the date of the delivery on sentence under Article 76 of the statute. I would like to take the opportunity at this point to thank everyone in the courtroom, the parties, the participants, our interpreters, security, and of course our members of the public gallery present here or following online. And with those brief comments, this hearing is now adjourned.
All rise, veuillez vous lever.